Good afternoon, everyone, and thanks for sticking around for this session on jurisdiction and contracting for cloud services. So just to a quick look at what I'm going to cover in this session, we'll look at jurisdiction and why it's relevant for cloud computing services, and how contracts in the markets at the moment deal with jurisdiction and applicable law. And then we'll look at cloud computing contracts more generally, the way they're similar to technology contracts in general, and the way they treat some issues differently. And then finally, we'll just have some thoughts about best practice and about the way the market might move. So this session's about jurisdiction. What is jurisdiction? Well, that means both the legal system within which you have to operate and within which your suppliers and customers operate, and also the legal system that governs the terms of your contracts with your suppliers and your customers. And why does that matter? Well, at a business-to-business level, it's kind of obvious you have to comply with the law, and that means you have to know which laws you have to comply with. And in the cloud, those laws could be numerous and variable because the activity is carried out across borders. You might have to think about the law that applies to your service provider, that applies to yourself, your customers, and the laws that apply in the countries where your data is stored. And secondly, if a problem comes up with your contract, it's not much help to you if you don't know where and how you can enforce it. So you need to think about that. And then, from the point of view of business to consumers, national laws protect consumers, and those national laws can differ from country to country. And it may be mandatory to comply with those, so you need to be aware of those obligations. And one difficulty that can arise if you're providing services to consumers, but your cloud providers have a business-to-business relationship with you, is that your contracts with consumers might have to include provisions which you won't get from your cloud provider. So you need to think about managing that gap. So you might be thinking, why do we need to think about national laws? And well, you do, because really the idea that online activity isn't subject to national laws and that national governments would effectively give up control over what goes on online has really died a death. And since the Yahoo case in France in 2001, it's been very apparent that national courts will assert jurisdiction over online activity. So in the Yahoo case, the Paris courts decided that French laws prohibiting sale of Nazi memorabilia did apply to Yahoo, even though that was a US-hosted website in the English language. So you need to look at your contract and think about all the principles you'd apply to a more traditional contract. And bigger, more advanced vendors are starting to recognize the relevance of national laws for their customers by applying geolocation technologies so that they can offer to the customer the contract which suits their location. And another reason to think about national law is that local laws might apply regardless of what law your contract is under. So for example, some consumer protection laws, some privacy laws, laws about internet filtering and censorship, and tax provisions you'll have to address regardless of what your contract says about applicable law. So a look at what's going on in contracts in the market just now in terms of jurisdiction and applicable law. One of my colleagues, Christopher Millard, has a kind of double life as a lawyer and as an academic. And with his academic hat on, he'd looked at the terms of several cloud provider standard contracts and assessed, to what extent those apply the laws of different countries. And probably not surprisingly, as you can see from the slide, the conclusion was that the majority of the contracts offered by cloud providers provide for the law of a US state, most often California, to apply. But there is a move in the market towards contracts allowing for the law of the consumers. So some contracts will specify English law for EU consumers. Some contracts will even specify that the customer's local law applies. But slightly more worryingly, several of the contracts out there will not express the choice of law, or it'll be ambiguous. And that's less of a problem in a traditional contract where you've got, say, an English company contracting with an English service provider for services that will be provided in England. A court is not going to have too much trouble trying to decide, well, which law applies there. But with cloud computing services, it can be a bit more difficult, and the fact that there's no applicable law specified might make it more difficult to interpret and enforce your contract. So some practical thoughts on jurisdiction. Just like with any other contract or any other activity your business is involved in, you need to think about the legal and regulatory constraints that apply to your business and the service and try to work with them. As we've seen, an off-the-shelf cloud solution is probably going to specify that a US state's laws apply to your contract, but if you need local laws or prefer local laws, those are being offered by some providers. So you need to think about what laws your business actually has to comply with and make sure that your contract isn't going to prevent you from doing that. So, for example, if you're an EU data controller and you have to comply with EU data protection law, even if your contract with your provider is under US law, you need to look at it and see whether it's going to enable you to comply with your obligations under EU law. And you might need to make some changes to the contract in order to be able to do that. One thing to remember is always to make sure that a jurisdiction is actually specified in your contract in terms of the forum for resolving disputes about the contract. Because if it's not clear, there are default rules that apply that will resolve the issue, but you kind of don't want to go there because the rules might come up with a solution which doesn't suit you, or they might be hard to apply in the cloud context. So, for example, in business-to-business situations, the rule is that the jurisdiction will be that of the defendant's home. So if you're suing on the contract, your defendant will have the advantage of a home jurisdiction. Or depending on the type of claim, it might be the jurisdiction where the obligations should have been performed. And trying to establish that in the context of cloud computing could be quite tricky. And for consumers, the default's likely to be that the jurisdiction will be the consumer's home jurisdiction. So it all can get quite messy. So you're better off just specifying the jurisdiction to begin with to avoid that problem. So look at where we are now in the market in terms of cloud contracts and contracting for cloud services. And I think there's still a perception and to a large degree a reality that cloud contracts often really aren't up for negotiation. And you can see, obviously, the point of cloud services to some extent is that they are off the shelf, and the fact that the provider is offering the same service to many customers is what enables them to offer the flexibility and the price advantages that are associated with cloud computing. So many service providers just use click-wrap terms where you click here to accept the terms, and you really don't even have the opportunity to negotiate those terms. And those click-wrap terms may say that the vendor has no liability for any service failure. They may say the vendor can subcontract to any third party at will, so you don't really know when you haven't chosen who's providing the service. They may say that the vendor can just terminate the service at any time for any reason, and they might not really give you any rights when that happens, so you might not even have the right to get your own data back. So this being the legal bit, you'd probably be disappointed if there wasn't any Latin, and it's a case of caveat emptor. You need to look at the terms, think about whether you can live with them in those situations. But that's not always the way it works. And vendors are starting to recognize that there are limitations to that sort of one-size-fits-all approach. And the market can, the way these click-wrap terms are being used is kind of following the trend of how shrink-wrap terms were used for software licensing in the 90s. So some of you, anyway, probably remember buying software on a disk in a box. You'd open the box and there'd be a bit of paper that sort of set out the license terms. And as time went on, that bit of paper had more and more pages to it and got thicker and thicker because the contract would start saying, well, if you're in England or if you're in the UK, turn to page 41 for the terms that apply to you. Or if you're in the Philippines, turn to page 56. And that change was driven by local laws that you can't contract out of. So some limitation of liability provisions, some provisions saying that no warranty will be given, some data privacy provisions will either be void under national laws or will just not meet the needs of the customer. And similarly, in business-to-consumer transactions, so many national laws provide protections for consumers that apply regardless of the applicable law for the contract, that actually it becomes a risk from the service provider's perspective to have a California law contract with terms that work under California law, because those terms could be void under European law. So the vendor can end up going from a contract that says it has no liability whatsoever to effectively having unlimited liability because the clause itself is just completely void. So in some respects, cloud contracts are no different really from any other technology contracts. The sort of essential features are the same. You'll need a right to use the service, the sort of really key terms in terms of price, scope, and service levels, terms dealing with risk management issues like privacy, security, access to your data, and possibly audit, and risk allocation provisions like limits of liability, warranties, and indemnities, terms dealing with the future and how you can get out of the contract, how the service provider can get out of the contract, and what happens if there is a termination, and boilerplate clauses dealing with stuff like jurisdiction that we've talked about. So all those things have to be dealt with in a contract for cloud services, just as in any other technology contract. But some issues have a kind of greater importance in a cloud computing context. So the issue of where is your data stored and who can access it becomes more significant. And you might want to think about whether, in what circumstances does the contract say the vendor can provide data to third parties. So some vendors will agree that they'll only provide data to third parties if the third party's got a court order saying that they have to, and some need more flexibility or their standard terms provide for more flexibility, which may be a concern for you. Similarly, some vendors will say that they'll only store data within certain geographical restrictions, and some won't, and sometimes you'll have a choice. And again, the issue of who's actually providing your service and does your contract reflect that becomes significant, because cloud services can be quite complex. There can be quite a lot of dependencies on third parties that might not really be reflected in your contract. So some of those features will be similar, but in some respects, a cloud contract might look a bit different. You need to make sure that you've actually seen all the documents that make up the terms and conditions that apply to the service you're getting. So you might look at terms and conditions, but then also you'll need to look at service level agreements, and there might be privacy policies or acceptable use policies on the website through which the services are accessed that you need to understand. And every IT deal is really made up of these three elements of price, scope, and service levels. So what are you getting, how much is it costing, and how good will it be? And if you change one of those, you're going to have to make changes to the others. They're all interrelated. And so there's been a lot of discussion about the fact that often SLAs for cloud computing services don't really state a commitment to achieve a particular service level. It's more like a statement that the service will be provided as is, which really means no obligation to provide the service at all. So you're kind of left with a license to use the service, the as-is service, and the obligation to pay, obviously. But you want to think about whether that's necessarily a bad thing. That might work for what you need the service for. So it's just a function of that interrelationship between price, service levels, and scope. So thinking about the future, at the moment the way cloud contracts tend to work kind of addresses some problems with traditional IT contracts. So you avoid this kind of long-winded, lawyer-heavy, a lot of negotiation kind of process where you're trying to sort of identify every possible risk. And you're avoiding a situation where you're ending up negotiating service level agreements that really don't drive or incentivize the behavior that you want, and you're getting a higher level of service, but you're paying for it. So arguably, sort of dealing with the sort of standard cloud computing approach where you have a click-wrap license means that you just get what you want without wasting a lot of time. But again, arguably that approach might change in future because it limits the market for these kind of services. Because some customers for some services will need a lot more certainty about the service's reliability. Some customers will need more understanding and visibility over how the service is actually provided. Especially for customers in the financial services sector, they might have obligations to know how the service is provided. And a particular worry for a lot of customers will be a lack of control in terms of termination or abandonment of the service. So one example of that was the Ghost service, which was a sort of data storage service, which just emailed its customers and said, we're shutting down in 2 weeks, move your data during the next 2 weeks. And if you're a small business with your data stored in that service and your IT guy's on holiday in those 2 weeks, you're kind of in trouble. So standard terms are evolving to reflect these concerns and the regulatory context that some customers have to work in. And also, they won't advertise it, but some vendors will negotiate terms for the right deal. And one sort of high-profile example of that that's been quite publicized was CSC and Google's contract with the City of Los Angeles. And that contract, I think because City of Los Angeles as a public body has ended up being published, and those terms reflected changes from what Google would normally agree to in their standard offerings. So they agreed, for example, to store email data only within the US. But you kind of can't overstate the significance of something like that, because obviously agreeing to store data only in the US for the City of Los Angeles is a bit different to saying, oh, we'll store data only in New Zealand or something like that. So it very much depends on the overall deal. We've mentioned SLA and a few more thoughts about those. We said that the common approach with cloud services is for the provider to say that the service is provided as is. But if you need more, there are likely to be cost implications involved in asking and getting more. But you might want to think about the approach to doing that. Because with the sort of options you have there, you could say, well, the supplier will ensure that the service is available 24/7, but no service provider can really do that. So what about use best endeavors to ensure that the service is provided 24/7, or reasonable endeavors? And the difficulty with those kind of provisions is that what you're really going to end up with is an argument about what best endeavors or reasonable endeavors actually means. So something a bit more granular along the lines of the last bullet point in terms of an obligation to provide services consistent with good industry practice, aiming to achieve 24/7 availability, but endeavouring to provide so many hours notice before emergency maintenance, and making sure that maintenance is outside UK business hours, for example. It looks worse than the ones above, but it might actually get you more in terms of certainty. The other thing to think about when you're looking at an SLA is what are the consequences if the service level's missed. And service credits might, in some respects, they might end up just being built into the cost, and you're going to end up with a higher cost, when what you really want is the service to be performed to the standard that you need. So one thing to think about is linking breaches of service level agreements to a right to terminate. And that brings us on to the next slide. So the SLA, on an as-is basis, really saying we have no obligation to provide the services to a particular standard, has concerned a lot of commentators. But in practice, you might be more concerned about terms that really lock you into the service, either because you don't have rights to terminate that are adequate, or because when you do terminate, you can't get your data back, or you can't get it back quickly enough, or you can't get it back in the format that you need. And really that can be more damaging than an SLA that doesn't work, because it means that you just can't walk away and take your business elsewhere. So from a contractual point of view, make sure that you've got a right to terminate on notice. So that could be a problem in a sort of traditional outsourcing contract, because the vendor's got upfront costs that it needs to defray, so they need and expect to see a sort of minimum term for which you'll take the service unless there's breach. But it shouldn't be a problem with cloud services, because the infrastructure is already there and it's not been set up specifically for you. Make sure that on termination you've got the right to obtain your data in a format that works for you, and make sure that the vendor has to do that reasonably quickly. And you might want to think about agreeing to pay a sum up front for that, or agreeing the sum that you're going to pay on termination for that, just to have the certainty that you're going to get your data back. And from a technical perspective, make sure that the format you specify in your contract is one that will enable you to take the service back in-house or to go somewhere else. It's not something that's going to be difficult to work with. So a few thoughts about best practice. And best practice is evolving as the way the contracts work is changing. But if you think about these kind of things, you'll be well placed. So think about the layers behind the service, who's actually providing the service, and what are the dependencies, what is your vendor relying on. Think about who's actually controlling the infrastructure that's key to the services you're getting and where that infrastructure is located. Think about where your data can be processed, where it can be stored and accessed. Is it okay with you that it could be anywhere in the world and that the provider might not necessarily even know where the data is? And think about who can access the data. You know, can regulators in different territories get hold of the data if it's stored there? You know, can litigants get an order for it to be disclosed because it's stored there? Look for what your contract says about if your provider goes out of business. What rights do you have in those circumstances? And how easily can you switch to a different vendor or go back in-house if your vendor disappears or if the contract's terminated? Make sure that you've seen the whole contract, so every document that might apply, even if it doesn't have a label that makes you think it's a contract. And think about how what you're getting fits with the regulatory requirements that you have to live with and the contracts that you're offering your customer. And the one certain thing, lastly, is change. So think about how your contract addresses change. Often they'll say that the vendor can change the service without notice or at will. And you want to think about whether you can live with that and whether maybe the contract should specify some sort of consequences if that happens and you're not happy with the change. That's it. So if you have any questions, thank you very much for listening. Hi. In terms of the service provider's liability, I think that it probably is something that can be dealt with on a contractual basis. And it probably depends to some extent. The laws in some countries will give some relief from liability for transmitting data that might be against the laws of some other countries if you're just acting as a sort of conduit and you've got nothing to do with, you're not publishing the data, and you don't really have control over it, you're not changing it or exercising control over it, you're just passing it on. So the laws themselves might provide some protection for the service provider in those circumstances. And I suppose the other thing you think about is looking for indemnities from your customer about the data that they provide to you, and if that breaches laws in some countries so that you're fined in some way, that they'll indemnify you for that. Does anyone else have any questions? Yes? Yeah. Yeah. I think the jurisdiction provisions for data protection, they are quite complicated, but the sort of fundamental thing about it is that you need to think about where the data controller, it's the data controller's obligations, and you need to think about its obligations. So I think there are provisions in the Data Protection Act that enable you to decide for a particular data controller. Firstly, does EU law apply? And secondly, which EU law applies? And it depends on really which context, where the data controller is established and how the activities are being carried out. Any other questions? feeling is that there is that sort of understanding that, yes, we're in a new age and these are new services, and so there's a sort of an acceptance of them being provided as is, but that is keeping some customers away from cloud services. And that probably will change, but it will mean more negotiation of the contracts for the services. So I haven't been aware of litigation around contracts for cloud services where maybe the service levels have been very low, or there hasn't been a service level and something's gone wrong. But that might be because the contracts are, customers are looking at the contract and saying, well, I don't think I've got much scope to sue here. I knew what I was getting when I got into this, and I thought it would do for this deal, for what I needed the service for. So it's not something I'm aware of, but we may start to see it over the next few years. Any other questions? Everyone had enough for the day? Yeah. Okay, well, it sounds like it's time for a drink then. Thank you very much.